We had filed a motion or two in the district court, which is the place where we demanded relief. Most of the jurisdictions that we do this in want to argue that the proper venue is in the circuit court, although when you're arguing about immunity, what meaning does immunity or have if you have to wait till trial? It really doesn't. It's meaningless. But nevertheless, we brought before the court the issue of immunity, a federal theory, which is that because the finances of the accused were tied up in, because of the forfeiture, they didn't have access to it, they couldn't hire the lawyer of their choice. They couldn't pay their lawyer. I say, and it's an interesting issue because the argument bends on the Fifth Amendment right to counsel and the versus the forfeiture statute. Jeff? It's Lewis, People versus Lewis case, which requires the court to recognize the Constitution in favor of the statutory forfeiture scheme, whereby that untainted money had to be returned. And that was a case that a physician, I think, had $50 million in some kind of healthcare fraud, and they were able to figure out of what was not earned from illegal aspects and ordered the money to be paid to the defendants so they could pay their lawyer, essentially. Anyways, that was one of the issues. But the other one that was most compelling is the one that the court ruled on, which was that the seizure of the search warrant, which resulted in the seizure of whatever the charges were that arose out of the Garden City case, was invalid, that there was no probable cause, that those things that I was talking about in the affidavit, which were not a basis of a crime, were enough in the court's review, the judge in Garden City in his review, to substantiate the probable cause. The leading case on this is a case we talk about. It is not the Brown must die case that we speak of, which is Anthony Brown. This is the Ricky Brown U.S. Federal Sixth Circuit case that speaks to an issue that has been used negatively against patients and caregivers, and is one that is of great importance, I think, for Michigan, because if the idea is that, in this case, is that Ricky Brown, a defendant, was unequivocal for the facts in the discussion, a drug dealer. He's driving in a car with someone who they've done 9 or 10 controlled buys with. They have drugs in the car. They're going to sell drugs to somebody. They're being followed, and they get arrested. And it's unequivocal for this purpose that they are drug dealers. So it's known at the time when they're arrested that that's what they do. They sell drugs and they make money from it. It is learned when they're taken into custody that Ricky Brown lives at a house and has an address that they learn of from his identification in his wallet. And as it goes, and as we see in many affidavits and their training and experience, all drug dealers keep more stuff, insert whatever that may be, at their house. And training experience tells us that if they go there, they're going to find these particular things. And as I said in this case, in Garden City, they framed it in the need to look for records because their training experience has deemed drug dealers, medical marijuana, allegations of noncompliance, elevate you to drug dealer status that equates to the officer's training. That'll tell you there's drugs at the next house or records at the next house. But in this Ricky Brown case, they go to his house and there's nothing else that existed to lead them to believe that there would be some contraband of any kind, something that would, some kind of suspicion even that there was or probable cause that something criminal was taking place within the home. And it's a great case. The court struggles with this issue, which has been litigated back and forth in the courts for many years, and there's many cases that say that's enough to get into the house of a drug dealer, and obviously you got affidavits that have been relying upon that, but this case ends that essentially and says there's got to be more. Can't be just that they live there. There's got to be some nexus of the illegal trafficking defendant that's been arrested and a connection to some kind of illegality that they can identify, particularize in some way. That's the key. Particular activity that they can identify as being suspicious or a probable cause that it's illegal and that they can get in there and get it. And in this case, there obviously wasn't. And there's other people that we know that the same kind of ruling is taking place. But it's a great, and some of the discussion that goes on this issue is, what point does, if you don't have this case, at what point does it end? Let's say someone's driving in, Texas. They live in Michigan, and they've got a pound of marijuana in their trunk, and they pull them over. Does that mean that that's probable cause and going to their house in Michigan? I mean, when does it end? When does that line end? When it be they're deemed a trafficker? When are you going to call? Because the other way, the slippery slope in the other direction is, it can be outrageous. You come, to leap over the Fourth Amendment for basically any kind of drug, anything that's deemed contraband. And so it's a great case in that respect. And I believe it was officers from the LawNet, in fact. We've come across them, if I remember, from the opinion. But we'll have to check that. Anyways, so returning to the Garden City case, this is what we relied upon. And as it goes, the prosecutor did not really have a lot to argue about, and it was rather enjoyable. I know, Alan, if you're listening, you would agree, and I think you had the same kind of joy. And this rarely happens when the court, fully prepared, read the entire story. And there was a really funny moment before we got into the gist of it, but and the judge was trying to get his research and get his the file. He'd done a bunch of work in his office, and he was looking for it. We spent a bunch of time kind of spinning around and waiting and whatnot. And then he's like, "Fine, I'm going to go get it." And he disappeared, and I'll be right back. And we're going to take a break. And everyone rise, and he left. And then he was literally back in a second and a half. It was almost like a TV show. He was, they kind of cut real quick where all right, everyone rise. Okay, everyone back up. He couldn't even. It was funny. But as he came back, I was really prepared to hit a stack of research, and he began to. I don't know. There's some great words I read. There's just nothing that tells me that there's any kind of illegal activity going over the house. There's no nexus. Everything that I argued in my brief, he was coming out of his mouth and just kind of. And it's true that it wasn't a case that was disputed on the facts. There was no. It was very clear that the affidavit said very clearly what it was that got them to the house, and the prosecutor's best arguments were, well, another judge thought there was probable cause. Judge blah 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 over in that court thought there was. Judge, well, because what I mean, because it requires to be well, maybe late at night or something. I don't. What do you get? But it was. And the hardest thing for me while it was going on, I'm going to finish this right now. Hardest thing for me while it was going on was not talking. I got to say that. I kept wanting to argue, and the judge had it. He's looked at me when first time I got in there, and he's like, "I got this, Kamor." No, it wasn't. It was. There wasn't really a lot to go on, and he read it in circumstances like that. I hate to even say it would be expected. I don't say that regularly, and wouldn't expect. It would have been a great case to appeal. We would have fought it in the circuit court, and who knows, they may appeal also. But I think, the law is on our side. Jeff Frazier, any comment on that?
Oh, good.
Okay. All right.
All true.
Amen.
All right, so I guess that's it. I guess we're right on time to do our break. Shyler,
Right on time.
Shyler here? Does Shyler want to come in and talk about anything? Because we can entertain that. One of our. All right, never mind. All right, we will be right back. Listen, Planet Green Trees, officially episode number 382. I think we've got Shri coming in next, right? Is that right?
That's right.
Calling in?
Confirmed.
All right. And then we have, I think Steve Miller will be calling in a little later.
Steve Miller is actually in the queue.
Okay, that's outstanding. And I guess we'll be right back. This is Planet Green Trees. What's the call-in number, Jim?
It's 224-803-3098.
Right.
Sweetness, I was only joking when I said I'd like to mash every tooth in your head. is nice and shyness can stop you from doing all the things in life you'd like to. Shyness is nice and shyness can stop you from doing all the things in life you'd like to. So if there's something you'd like to try, if there's something you'd like to try, ask me, I won't say no, how could I? Coyness is nice and coyness can stop you from saying all the things in life you'd like to. So if there's something you'd like to try, if there's something you'd like to try, ask me, I won't say no, how could I? Spend.
Alrighty, we're back. Thanks for staying with us. Episode 382, Wrong Answer is what it's been called. Am I responsible for that? I understand the queue. We have the next governor of the state of Michigan calling back in. And I understand a long-time listener of Planet Ranger, a recent long-time listener. The first thing we're going to do is our question about recent episodes just to make sure we can clarify that. Just kidding. Please welcome Shri.
Hi, good evening. How are you?
Very good. Thanks for coming back on the show. How have you been? How's the campaign going?
Oh, I've been good. I'm here in the parking lot of, I think, Channel 2. I have a live show, Let It Rip, at 10:30 tonight. But I am just called in to just say hi to you and tell you some good news.
Yes, please. We love good news.
Good. So recently, Epic MRA did a poll. And the poll of